I'm George McCranie, DUI, criminal defense, and serious injury attorney with offices in Douglas and Valdosta, Georgia. We've had a lot of questions about, at a trial, what the state has to prove. What's their burden of proof? And the burden of proof in Georgia is the state has to prove beyond a reasonable doubt that the defendant is guilty. Now, what does that mean, beyond a reasonable doubt? Most people don't understand what it means, and the fuller phrase is the state has to prove beyond a reasonable doubt of a fair-minded juror, okay? Now, the best way I know to explain beyond a reasonable doubt is to give you examples of it. Now, the judge will explain to the jury, beyond a reasonable doubt doesn't mean, ladies and gentlemen, doesn't mean 51% guilty, doesn't mean 65, 75, 85, 95, 99% guilty. It means exactly what it says. It means that the state has to prove their case beyond a reasonable doubt of a fair-minded juror, okay? Now, for me, I'm from Willacoochee, Georgia, very small town. To me, that doesn't tell me exactly what I'd want to know if I was a juror. So I'm going to move the camera around here just a second. I'm going to show you an aid that I use, a visual aid that I use whenever we have trials to help explain what beyond a reasonable doubt is. Y'all pardon me for moving the camera here. And if you'll take a look, this is what we have for beyond a reasonable doubt. Now, at the very bottom is no evidence. There's no trace of evidence whatsoever. Next step up is scintilla. And it's just the smallest amount of evidence that you can have. Beyond that is reasonable suspicion. And reasonable suspicion should be based on specific and particular facts or reasons, not based on a hunch or a guess, okay? Not, I think the person might have marijuana in the car because they look like they smoke marijuana. That's not it. They've got to have actual reasons, okay? Probable cause is the next step. Reasonable and trustworthy information that a person has committed a particular crime. When you go above that, the next step up, and as we go up, we're getting closer and closer to beyond a reasonable doubt. The next step up is preponderance. There's a greater weight or amount of evidence involved in the case. Then you have clear and convincing. Clear and convincing evidence is a firm belief that the allegations are true. But even if you have clear and convincing evidence, that doesn't mean that you can find the person guilty. The highest step on my visual aid here is reasonable doubt. And if you find that there's reasonable doubt, it still requires a not guilty verdict. Now, what you have to do is you have to actually go beyond a reasonable doubt. And now, the way that works, and I've done this, I'll tell you what I'll do. I'll give you an example. And I've done this. This is an example that I have given for years and used and used and used. And it seems to explain it pretty well to most jurors. Now, here's what we're looking at. Let's say we've got a trial, jury trial, and the person's been charged with speeding and DUI. That's all they've been charged with. No failure to maintain lane, no reckless driving, no crossing the center line, anything like that. Just speeding and DUI. Well, we have the trial, it gets started, and we have opening statements at the beginning. At the opening statement that I give, I'll explain all the evidence that I think that we're going to be able to prove and it's going to be able to come in, and I'm going to argue later on that that's the evidence and it's not enough to prove my client's guilty beyond a reasonable doubt. But I also talk about the state's evidence. And I say, the state's evidence, ladies and gentlemen, I want y'all to think of it as the state's box that they fill up with evidence. And we'll talk about that box later on. Now, after the trial, and we've gotten down to where we're having closing statements. After all the evidence has come in, the officers have testified, everyone's testified. This is what I get into usually to explain reasonable doubt or beyond a reasonable doubt. I'll explain about the judge. The judge is going to tell you that it's not 75, 85, 95, 99% guilty. That's not the standard. The standard is they have to prove beyond a reasonable doubt of a fair-minded juror. So I say, let me give you an example. Let's take a box, imaginary box, just like you'd buy a TV in. And let's put it down here in front of the jury. All right, now we open that box up, and in the box we put a mouse. And we close the lid back up on the box, and we wait 5 minutes. We go back, we come over to this box, we open the state's box back up again, we don't look in the box, and we put a cat in the box, and we close the lid. We wait 5 minutes. Now, if you come back and you open the lid on the box and the only thing you see in the box is the cat, then you can believe beyond a reasonable doubt that the cat ate the mouse. And if the cat is the only thing you see in the state's box, then you'd be authorized to find my client guilty. But if you look in that box and you find one hole, the mouse could have ran out of that hole before we ever even put the cat in the box. Now, let me tell you about all the holes in the state's case. You remember the officer testifying. He testified that in his training, that speeding is not an indicator that someone's impaired. In fact, speeding safely with the absence of any other charges is an indicator that the person is able to drive safely because they weren't weaving, they weren't failing to maintain lane, they didn't cross the center line, they didn't leave the roadway. Actually, the speeding charge, and you heard him testify, it's harder to speed safely than it is not to. Okay? So here's what we're looking at. That's the first hole in the state's box. My client was only charged with speeding, no indication of impaired driving whatsoever. And then I go on to try to put holes in that box to make it look like you shot it with a shotgun. Okay? Now that's the best way that I know to explain reasonable doubt to people. And I use it often in trials, and it's very successful. I've had great success with that. So if this is a question that you have about what is beyond a reasonable doubt or what they have to prove in a criminal trial in Georgia, and when I say they, I mean the government, what the government has to prove. Remember, you don't have to testify. You don't have to give one bit of evidence in a criminal trial in Georgia. They can't make you do it. All right? Sometimes it might be in your best interest, sometimes it might not be, but they can't make you testify. That explains beyond a reasonable doubt here in Georgia. If you got any questions, feel free to give us a call. You can reach us at 833-927-6227. You can also text us. You can text to 855-900-7244. And if you'll text us, we'll reply to you and get you some answers that you need. Now, if you've been charged with a crime in Georgia, remember this, and this is what I always advise people. Admit nothing. Deny everything. Demand proof, and then get you an experienced lawyer because you're going to need it. Okay? Thank y'all. I appreciate you watching. Again, I'm George McCranie, DUI criminal defense attorney and serious injury attorney with offices in Valdosta and Douglas, Georgia. Thank y'all.